I am Conti Moore Smith. I'm a family law attorney and I practice primarily in Central Florida and in the Orlando area. And so I'm excited for you to join us today as we talk about custody, child custody. And in Florida, we really don't use the word custody. We refer to it as time sharing, but it's the same meaning. So custody, or as we say in Florida, time sharing. And how does a court establish a time sharing schedule? And so we're going to talk a little bit about that. A lot of people ask me, well, does the mother get, special treatment because of the mother as it relates to time sharing or custody of a minor child? And according to the statute, it is gender neutral. So there's no preference for whether it's the father or the mother. In the statute, it doesn't say anything about either parent getting a preference based on their gender. People also ask me, well, shouldn't we just start at 50-50 time sharing? Is there a presumption in the statute that, equal time sharing is appropriate for every child? And the answer to that question is no. The statute does not have a standard time sharing schedule set forth within it. The primary concern, the primary factor that the court considers when determining a time sharing schedule in Florida is what is in the minor child or children's best interest. And so time sharing is basically determined on a case-by-case basis. So you really can't look at what happened for other parents, for another child. You have to really look at the facts that are involved in your particular case. So there is no one-size-fit-all formula in Florida. So when the court is trying to determine what is in the child's best interest, there's a statute, it's Florida Statute 61.13, that sets forth various or several factors that discuss how the court determines what will be in the child's best interest. And so I will go over some of those factors and give you an example of what the courts will look at and consider, and some facts based on each factor. So the first factor the court looks at is the demonstrated capacity and disposition of each parent to facilitate and encourage a close continuing relationship with the minor child. So if there's a parent that is trying to alienate the other parent, if there's a parent that's talking poorly about the other parent, a parent that doesn't want the other parent to have time sharing, the court will consider that as it relates to that factor. The court wants to see that each parent is going to be willing to allow the other parent reasonable access to the child. So you want to make sure that when you're communicating with the other parent, that you are displaying that you are going to put the child's best interest first above yours. Another factor the court looks at is the anticipated division of parental responsibilities after litigation, including the extent to which parental responsibilities will be delegated to third parties. So if you have a schedule where you work 7 a.m. until 7 p.m. Monday through Friday, and you cannot take the minor children to school, and you cannot pick up the kids from school, you have to rely on a third party to assist you with caring for the children, the court may consider that as well. Another factor is the demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child as opposed to the needs or desires of the parent. This factor goes to, really the child being put first and not the parent. So even if the parent has issues with the other parent, the court wants to see that you can get past that and that you can put the child's best interest first. Examples of this may be if it's one parent's time sharing for the weekend and another parent has a family event the child wants to go to. Will that parent be reasonable and let the child go to that function, or will the other parents say, well, no, it's my time sharing. I don't care if the child wants to go. I don't care. It's more about my feelings than the child's feelings. So the court will consider that as well. Another question or another factor that the court considers is the length of time the child has lived in a stable environment. If you have one parent that is, constantly moving, every year they move, the court may say that's not stable. If the other parent has been at their residence for, several years, the court may think, or may consider that parent's stability, outweighs the other parent who's constantly moving, and that for that factor, that other parent, they will give more weight to the parent that has demonstrated stability, if that makes sense. The geographic viability of a parenting plan. So people, call and they say, I want 50-50 time sharing. And my first question is, how close do you live to the other parent? If you live 30, 45 minutes, an hour, or 2 hours, it's going to be really hard to accomplish a 50-50 time sharing plan. So the court considers, how close the parties live to each other when determining how much time sharing to award to each parent. I've had some people call me, well, I live in California and the child's in Florida. It's going to be very difficult to get a 50-50 time sharing schedule when you live on different sides of the country. It's even hard when parents are, 45 minutes apart to award a 50-50 time sharing plan. But again, each case is different, and it depends on the factors in that case. If you have one parent that doesn't work, who can transport the kid, every day, that, may assist the court in providing the relief that that parent wants. They consider the moral fitness of the parents, the mental and physical health of the parents, the home, school, community, and record of the child. And sometimes they will consider the child's wishes, right? What the child wants to do. So this factor, it says the reasonable preference of the child. If the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference. So it's highly unlikely that the court's going to, give a lot of weight to that factor for a 5-year-old or a 6-year-old. If you have someone that's maybe 16, 17, or 15, the court may give them may take into consideration what they want more than a child that's repeating what a parent said to them. So that's something to consider as well. They also want to look at whether which parent can provide a constant routine for the child, and if which parent has a demonstrated capacity to communicate with the other parent about what's going on with the child. In some of these family law cases, you see parents that say, if the other parent wants the information, they can go get it from the school. Well, they can, but the court's going to look at how are the parents communicating, and and they may give preference to the parent who goes out of their way to make sure they keep the other parent informed, versus a parent who's just saying, I'm not going to give him anything or give her anything. They can find out on their own. That may not work well for that parent when they get to court or to get into trial. I had one case where the parent said that the other parent was not going to get time sharing until the court ordered that parent get time sharing. And I can tell you that in that case, that really didn't work out for that parent, because the court believed that parent was being unreasonable and was not allowing access to the children for the other parent. Some of the other factors that the court will look at is whether or not you kind of know what's going on with your child. In certain cases, you see where parents get put on child support, the child's 10 or 11, and they really haven't had any time sharing with the child. And then when they're put on child support, then they want to come back and they want to get 50-50 time sharing. Well, you really haven't been involved in this child's life for the past 10 or 11 years. Is it reasonable to expect that you are going to get 50-50 time sharing with the child? If you can't talk about, what the child's likes are, dislikes, if you don't know the child's teacher's name, if you've never been to a parent-teacher conference, if you've never taken the child to the doctor, it's going to be difficult to make the argument that you should be entitled to 50-50 time sharing with that minor child. Now, if the child is not 10 or 11 and the child is like 1 or 2, then you may be able to have a better chance of making that argument, because, hopefully at that point you're still trying to be involved in the child's life, and, it's not like you went years without being involved and now all of a sudden want to get involved when you got hit with a child support order. So the courts consider that, and they look at that and consider those different factors as well. So you want to make sure that if you're asking for a substantial amount of time, that you are trying to be involved, or at least show that you tried and the other parent wouldn't let you. So you want to make sure that you can demonstrate that as well. And then some of the other factors that the court considers is the demonstrated capacity and disposition of each parent to maintain an environment for the child which is free of substance abuse. That's important. And then also the capacity disposition of each parent to protect the child from the ongoing litigation as demonstrated by not discussing the litigation with the child, not sharing documents or electronic media related to the litigation with the child, and refraining from disparaging comments about the other parent to the child. It happens a lot where people include the kids in the litigation and, they're telling the kids what's going on. And the courts can take that into consideration when determining the time sharing schedule between the parents. So, you want to make sure that you shield kids from what's going on. Do not include them. This is adult business. They don't even know what's going on. And you want to make sure that there's no evidence of that, because that could work against you if you're the parent that is participating in that inappropriate behavior. So all of these factors are set forth in Florida Statute 61.13. If you want to go back and review them, make sure you're looking at those so you kind of have an idea of what the court considers when they're determining what's in the best interest of the child. And just to recap, there's no, one-size-fits-all approach as it relates to time sharing in Florida. It's really based off of what is going to be best for that child and that family based on the circumstances in that particular case. Now, if you have any questions, we offer free consultations. You can call us at 407-831-0203 to get a free consultation with us. If you have questions, please, I have more questions I'm going to answer. If you have questions, please drop the question in the chat. If you don't feel comfortable dropping the question in the chat, you can send me a DM, and I will either create a video or respond to you with the answer to your question based off of my knowledge of Florida law. You can follow us on Twitter, TikTok, Instagram, Facebook at Conti Moore Law. We post informational videos about different topics, so we may have already answered your question there, but we didn't answer it today. If you have any other ideas about topics you want to hear, please reach out to us. We would love to create some videos to help answer your questions. Have a great day, everyone, and remember to stress less and choose more.